Hello, everyone. Thank you for tuning in to Premium Law Access. Today, we're going to be talking about the Dream and Promise Act. That's the American Dream and Promise Act. And I guess what? This is the bill that was actually passed this week by the House of Representatives. That was so exciting. And we're hoping that it will still pass when it gets to the Senate and hopefully when it gets to President Biden's desk. So in this segment, we're going to be talking about this bill. From the name, the American Dream and Promise Act. There are two bills in one. So I'm going to break that down and you're going to be listening to the key facts. I'll be sharing all of those with you. So the Dream Act part of it concerns the dreamers, and those are the DACA applicants, the minors who came to the United States and have been here, went to high school, elementary school, college, and they're here and they have never been home. So this is to protect them, and this is to create a path to citizenship for those people. The other part of the act, that's the Promise Act, is for the humanitarian recipients, and those are the TPS, those who have received TPS or are in the DED status. Well, not really a status, it's a humanitarian ground. So if you are a recipient of those two, TPS, Temporary Protected Service, and DED, Deferred Enforcement Departure, the Promise Act of it will protect you and will help you gain citizenship. So I'm going to break that down. So for the TPS, they're estimating, TPS and DED, they're estimating about 400,000, about that, or even more. And for the DACA recipients, it'll be about 3 million or more who will benefit from this bill. So I want to let you know that this bill was passed by the House of Representatives. And this is not the first time it was passed. It's been passed before. And this time it was passed with 9 Republicans joining. So it's a bipartisan bill, which is good. But we're hoping that more people will join so that we can have a comprehensive immigration reform. So with immigration reform, I know everyone was expecting, that big bill, but I had told you that it's going to be a long haul and they're doing it piecemeal by piecemeal, and let's see how that works. But hopefully if they get to everyone, all the undocumented people, then that's still good. But this time we're going to talk about just this piecemeal legislation. So the bill is about 55 pages. It's different from that which was introduced in the Senate. This bill is referred to as the H.R. 6. And the one which was introduced in the Senate is referred to as S-264. So I'm now going to draw the distinction between the two bills. The H.R. 6, that's the one which was passed this week. And the S-264, that's the one which has been introduced in the Senate, but yet to be passed. There has no vote yet. So I'll start with the title. The H.R. 6 is the Dream and Promise Act of 2021. The S-264 is the Dream Act. That's only one bill. The H.R. 6 was introduced by Representative Lucille Roy Ballard on March 3rd of 2021. And the S-264 was introduced on February 4th, 2021 by 2 senators, Dick Durbin and Lindsey Graham. That's a Republican and a Democrat, which is good. So the similarities of both bills. So both bills are going to provide paths to citizenship for Dreamers, TPS holders, and the DED recipients. Both bills are also going to provide current, former, and future students of whether high school or those who are to obtain their GED, that's the General Education Development. They're all going to get a path to citizenship. And that's a similarity. So in order to be eligible for this bill, under the HR 6, that's the one in the House of Representatives, the age at arrival, the time when you arrived in the United States, you must be 18 years or younger. For the S-264, you have to be 17 years or younger at the time of arrival. Under the HR 6, you would have been continuously living or being present in the United States from January 1st, 2021 in order to be eligible. For the S-264, you would have been, in order to be eligible, you should have been continuously physically present for at least 4 years before the bill was passed. The HR 6, if you are eligible, you apply, and if you're approved, you will obtain 10 years of conditional permanent residence. The S-264, if you apply and you're approved, you will obtain 8 years of conditional permanent residence. So, who is ineligible to apply? Under the HR 6, the criminal bars are quite different. Well, very similar, but again, it's more extensive under the HR 6. So if you have a criminal background, no, you may not be eligible. There might be a bar. So when you're talking about bars, we're talking about felony, aggravated felonies. We're talking about misdemeanors. If you have 3 or more misdemeanors, and this is under the HR 6. If you have domestic violence, that could also be a bar for you to obtain this benefit. Under the S-264, if you have an aggravated felony, if you have drug-related offenses, if you have 3 or more misdemeanors, you may not be eligible for this benefit. However, there are exceptions to these crimes. So there are some crimes that will not qualify. Even if you have those crimes, you will still be eligible. And that you really have them more under the HR 6. So under the HR 6, there are crimes that they said it's crime related to lack of immigration status. And this applies to both bills. That's the HR 6 and the S-264. So what does this mean? It means that crimes like if you have overstayed or if you're undocumented, anything related to your immigration status, that can be excused or can be waived. Even when you have that, you will still benefit from this benefit. Crimes like minor traffic offenses, for some marijuana-related offenses, for nonviolent civil disobedience, for domestic violence, especially where you are the victim. Under the HR 6, you may still be eligible, you may still be eligible for this benefit, even if you committed those crimes. But the best suggestion or recommendation would be stay out of any crime. Have a clean record, so that way you're not subjected to further scrutiny. So under the S-264, the only exception they have is especially where it's a crime that's related to your lack of status. That's if you're undocumented or you overstayed your visa. Under the HR 6, there is a second level of scrutiny, and that is, it's called a secondary review process. So these are, if they review your application and they think you might be a subject of a threat to public safety, or you have belonged to the gang maybe within the past 5 years, or involved in gang activities within the past 5 years, yes, that may bar you from achieving any, I'm sorry, that may bar you from benefiting from this path to citizenship, this bill. So that way your application may be reviewed, and upon review, if they find any of these issues with your application, you may be denied. Under the HR 6, if there's a misdemeanor that's punishable by more than 30 days in jail, your application may be denied. And if you're a juvenile, if you've been subject to a juvenile delinquency judgment, and if you have had time to spend in the detention facility, your application may also be denied. So the key here is stay out of crime. And for those who have had past crime, if this bill were ever to become any law, try to contact either a criminal attorney or an immigration attorney before applying, so that they can see if there are any grounds of waiver, if you can be waived into any of these programs or granted waiver due to your past criminal history. So another thing the HR 6 does is it went on to repeal the 1996 law. Now, the 1996 law was a law which penalized states which granted the undocumented or the DACA recipients, the states which granted DACA recipients either access to financial aid or student loans and all that. So these states were penalized. So under the HR 6, it's going to penalize, it has repealed that 1996 law. It also, in addition, it's going to allow eligible dreamers or recipients of DACA who were deported under the previous administration, under the Trump administration. So under this new bill, those who were deported can actually apply for this benefit, even from outside the United States. So that's really the distinction between the two bills. The HR 6 is more extensive, even though it's 55 pages, and they're both similar, but what they both have in common is really that path to citizenship. So now I'm going to talk to you about the path to citizenship. What does it really mean? So path to citizenship, really, there are 3 stages. And this is common to both bills. So what are these 3 stages? It means, first off, the applicants, so people in these groups, DACA, TPS, or DACA, TPS, or recipients of DED. They can apply. I'm going to start with DACA, and that's under the American Dream Act. They can apply for conditional permanent residence. So conditional permanent residence, that you must have been a minor who entered the country as a child. You must have been a child when you entered the country, and you must have been admitted into a school. You must have gone to elementary, high school, obtained your high school diploma or your what do you call it, GED. So all those people who are, yes, eligible to apply. So when you have, as long as you have a good criminal history and you have not been involved in any persecution of maybe anybody else, yes, you can apply, and you have not been convicted of certain crimes, you can apply. So when you apply and you're approved, the status you get will be a conditional permanent residence. And it depends on which bill. Now, we don't know for how long you're going to have that status, because the HR6 is saying 10 years will allow you to have that status for 10 years, and the S264 will allow you to have that status for 8 years. So the status you will get will be conditional permanent residence. So after that, the next stage, like you hear, it's a path to citizenship. So after that stage, the next status you should be getting will be the lawful permanent residence. So for you to be a lawful permanent resident under DACA, you must have maintained your status as a conditional permanent resident. So you should maintain the terms of that status. When you violate the terms of that status, then maybe not. You cannot apply, or you can apply, but you might be denied the status of a lawful permanent residence. So under the lawful permanent residence, you must be a conditional permanent resident. You must have attended school, either obtained a diploma or a GED, or maybe a higher school, maybe college. You could have attended college, or even the two-year college too. That's allowed. So for either of these reasons, you would have attended a higher education. So there are 3 grounds under which you qualify as a permanent resident, for you to apply for a permanent residence. The first bucket is this higher education. That's if you've attended college, maybe you obtained a degree or advanced degree for 2 years. The second bucket will be where you belong to the military and have been in the military for at least 2 years. And if you're discharged, you get an honorable discharge. Yes, you'll be eligible to apply for your lawful permanent residence. Or if neither of these apply, if you have been working, and maybe 75% of the time you've been working, you have had your work authorization. Yes, you may be eligible to apply for your work authorization. So under these 3 groups, you don't have to comply with all 3. You can belong if you're eligible for at least one of them. So if it's school track you're going, or the military track, or the work part, one of them at least, in addition to having maintained your status as a conditional permanent residence. All this will enable you apply for your lawful permanent resident status. So after that, once you apply and you get that status as a lawful permanent resident, the next status will be citizenship. And for this, in order for you to be a citizen, you would have been a permanent resident for at least 5 years. So after 5 years, you're eligible to apply, and that's the normal processing for citizenship. Just the way you apply, you study the tests, you attend your interview, and if you pass, then that's it, the citizenship. That's exciting, right? So that is it for the DACA process, and that's it for the DACA recipients under the American Dream Act of 2021. Now, we don't know, like I said, we don't know which one, if there's going to be a compromise or if some parts, yes, we still expect maybe some modifications when it gets to the Senate. So I'm going to now give you the highlights of the American Promise Act. Remember, I told you that the bill that was passed by the House of Representatives are 2 in 1. That's the American Dream Act and the Promise Act. So now the Promise Act, I told you, it's now benefits, the Promise Act benefits TPS holders and the DED recipients. So how do they apply? For the TPS, you would have been in that status or maybe eligible for that status. And you can apply for lawful permanent residence if you have at least, if you can apply 3 years after this law has been passed, or yes, after the law has been enacted. So long as you apply after 3 years, within the 3 years after the law has been passed, you may be eligible to obtain your lawful permanent resident status. And then you must have been continuously and physically present in the United States for at least 3 years in order to be eligible to apply. So now we can't say if it's the HR6, if that's what you're adopting, then it'll be 3 years from January 1st of 2021. And then if it's the S264, they're saying you should have been here for at least 4 years. So what we don't know yet, but they're just saying from any time this act will become law, you would have been physically present for at least 3 years. There is also the fact that the criminal part, that you should have a clean criminal history. So really, the distinction now is for DACA, it's effective January 1st of 2021 if you're looking at HR 6. And then for S264, that's the Senate bill, you would have been here for at least 4 years. For TPS, they're just saying that you should have been here for 3 years. So that's really the distinction. There are subtle differences. That's the distinction. For TPS, you would have been here for at least 3 years after the bill was passed, and you would have applied within 3 years after the bill was passed. For DED has it that they're saying that under the HR 6, it's saying that in order for you to be eligible, you would have, it's going to be effective from January 1st of 2021, and you would not have engaged in any acts that will make you ineligible. Again, it's that criminal history. You can be a threat to public safety. You can be involved in drugs. All of those apply. And the good news, I will tell you, and this is the best of the news, is that even for those, it really does, it's so expansive and does not really exclude a lot of people. And I'll tell you why, because even if you are in removal proceedings, or you have a removal order, or you have a voluntary departure and you did not depart, you can still apply. You're eligible to apply. So that's good. So it means that anytime this law is passed, we're hopeful. Well, we don't know what will happen at the Senate because we still need the 60 votes. We still need 10 Republican votes. So if it passes at the Senate, then we're hopeful that President Biden will be able to sign it into law. So the good part is, I think it's all inclusive. It includes people who have had past crimes. Well, you apply, and if you apply for a waiver and you're not granted, then maybe not, you're denied, then you're out of luck. But if you have a clean record, yes, you might be eligible to apply, and all these conditions. Finally, I'm hoping that once we get the final bill, that it will streamline a lot of all these. Maybe it will streamline a lot of issues, and then bring in more people who will be eligible, and make the process more seamless, I would say, and hopefully a lot more people will be able to attain and aspire to become citizens. And I guess with all of this will bring me to the end of this discussion. And this is it for this new bill. Hopefully, maybe in the coming weeks, we don't know when the Senate will vote on theirs. We'll see what happens. So I hope you would have learned something from this discussion, and feel free to share this with everybody else. And if you have comments, please don't hesitate to let me know. Thank you so much for tuning in. We're hoping that this year, like President Biden said, that help is on the way, and indeed help is on the way. This is really a good start. We're just thinking it's just introducing the bills, or just introducing the bills in the House. But for them to have passed this bill, it's a very good step and a bold step forward. I know some of you will be disappointed and saying, okay, I'm not a DACA recipient, I'm not a TPS recipient, I'm not a DED recipient. It does not affect me, and I would not benefit from this. Remember, there's still the 11 million, there's still the documented, but they are doing it piecemeal. We don't know what the strategy is, but we're hopeful that they will get to everybody. So it's just for us to be patient and be hopeful. Thank you for tuning in, and hopefully I'll see you again next week as I continue to break down aspects of this bill. Okay, thank you and bye.